Good morning to everybody and the students of the Advanced Private International. Again, it is a class in absentia, but yesterday the people said that they would like to join and participate in my virtual class so that they could be benefited more. But regarding the controversy of the 5 or 3, of course that may be different. Even 3 also participated who are there in my class, and I feel that it would be the best to me. It's not too much late. Even today, you can fix a particular time, then you can ask me to conduct on particular time so that I will conduct it and you can participate it. So without wasting much time, let me pounce upon the subject. What is classification of private international law? I repeat, what is classification in private international law? In a civil case involving a foreign element, technically known as conflict of laws, the trial court will have to determine whether it has a jurisdiction both over the parties or the cause of action, and it will have to examine the cause of action to determine whether the case is one of the breach of contract or the matrimonial cause or the commission of a tort, or to determine which appropriate rule of law is applicable. The process of determining those issues is what private international law known as classification. I repeat, the process of determining these issues. How? Is it a matrimonial issue? It is a tort issue? It is a contract issue? It is a property distribution issue? So, is what under the private international law known as a classification. So, we can classify in that manner in which category it falls. Let me see the contents. Yes, the meaning of classification. How do courts use the classification in conflict of laws? Process of the classification in private international law. Classification cause of action and classification rule of law. Then a case law is there, famous Gharib Abdullah-Juma versus K. Milanga. I repeat, Gharib Abdullah-Juma versus K. Milanga. That is the 2001, the Court of Appeal at Zanzibar. Now let us see that how classification was applied in Gharib Abdullah-Juma versus K. Milanga case in the later part. Let us see the first meaning of the classification. And a classification is a term of the private international law. I repeat, classification in terms of the private international law is a selection or classification of causes of action and the rule of law applicable to dispute involving foreign elements. This means the allocation of the question raised by the factual situation before the court to correct a legal category. In the process of classification, the court is required to analyze the pleadings prepared by the parties and to assign each component element to the most appropriate juridical concept of category. In each case, when the case comes to the court, we can easily make it out whether it is having a proper jurisdiction or not, and what would be the applicable law, and whether there is a foreign judgment could be implemented or not. We can practically see it, how it can be dealt. The rules of any given system of law are arranged under the different categories: addressing procedures, status, contract, tort, divorce, nullity, and so on. So these are all the categories different under the private international law. How do court use a classification in conflict of laws? We can say sometimes the conflict of laws, or we can say the private international laws. But in the earlier classes, I made it very much clear. It is a UK terminology is a private international law, and hence In our syllabus also we will use the advanced private international law, but not advanced conflict of laws. So when courts faced with the case of foreign element, of course one foreign element is must in dispute here. And I have two-stage process. First, the court will apply the law of the forum. There is a lex fori. Lex fori means the domestic law of the court dealing with the case. And to all procedural matters, I repeat, in all procedural matters, including evidence rules and the choice of law rules. Of course, the procedural matter generally that what we follow is the lex fori only. Further, the court has to count the factors that connect or link the legal issue to the laws of potentially relevant states and applies the laws that have the greatest connection. So let us see one of the example, what it stated. The law of nationality, we can say lex patria. The domicile, lex domicili, will define the legal status and the capacity of the parties. For that, when you utter the lex domicile, then the remarkable and a classical case law we should have to come into your mind. Of course, the students are not present over there, otherwise I would have to ask them. The case law then is Ramsey versus Liverpool case law, or better we can known as Ramsey case law. So let us see the law of the state in which land is situated. There is a lex situs will be applied to determine all question of title. So it is a fundamental, the principle, later we can say the doctrine that movable and immovable property, generally the immovable property we can take it as a lex situs. The law of the place where the transaction physically take place or of the occurrence that give rise to the litigation, lex loci actus, will often be the controlling law selected when the matter is substantial. So, process of classification in private international law. Generally, the process of classification involves two things, namely, number one, classification of the cause of action and the classification of the rule of law. One is cause of action and another is rule of law, and which law will be applicable over there. So classification of cause of action. Every legal system arranges its rule under a different category which must form the basis of the plaintiff's claim. These categories may be concerned with the tort, contract, property, status, succession, and so on. So this is the classification, the cause of action. Therefore, the classification cause of action means the allocation of the question arising by the factual situation before the court its correct legal category. Then, the aim of the object of doing this is to reveal the relevant rule for the choice of law. Thus, once the forum court has decided that it have jurisdiction to hear the case, it then must characterize or classify the causes of action. This is regarded as the most important and difficult problem in the conflict of laws. Then next we turn to the classification of rules of law. Once the legal category of the given case has been identified, the next stage is to apply the relevant choice of law rules in order to identify the law of the place where the cause of action was raised, that is lex causa. So however, even at this stage, it may be necessary to classify a particular rule in order to determine whether it falls within one choice of the law rule or another. Generally, classification of the rule law applicable in case of will depend basically on the ultimate reasoning of the judge. There is no hard and fast rule on this. Nevertheless, the correct choice of law will depend upon some connecting factors such as domicile, the situation of the movable property, and the definite legal systems. Read the following case to understand how court applies the consent of application, and here I will share a summary. Now let us see the Gharib Abdullah versus K. Mlinga. That is a 2001 Court of Appeal at Zanzibar. The facts of the case goes like this. Gharib Abdullah Juma, he is a Zanzibarian, lived in Denmark, married K. Mlinga, a Tanzanian from the mainland in Denmark. So they married in Denmark, but the bride from the Zanzibar and the bridegroom from the mainland of the Tanzania. Denmark practiced the system of community of the property to married people. The law prevailing in the Denmark is that the system of community of property to married people. At the time, he owned a flat in Copenhagen. So Gharib Abdullah Juma decided into a premarital agreement with the K. Mlinga to exclude it from the matrimonial property. Before marriage, he had other properties, that is, 2 houses situated in Zanzibar. After the marriage, K. Mlinga went to live in Zanzibar. The marriage lasted some 14 years, and the two were obtained a judicial separation and were formally divorced, and both the judicial separation and the divorce occurred in Denmark. And I believe that the marriage took place in the Denmark. Perhaps that is the right place where they got the divorce, in Denmark. There was no order of the division of the matrimonial property in Denmark. So in the order, there is no division of the matrimonial property in Denmark. After divorce, he brought a suit for the division of matrimonial properties in the High Court of Zanzibar. Who brought? K. Mlinga brought. And K. Mlinga, she is a mainland from Tanzania. She wanted the division of property that Gharib owned before and after marriage, especially property situated in Zanzibar. To claim for the property which Gharib had before marriage, K. based her claim on the premarital agreement which, after excluding the flat in Copenhagen, provided for a complete community of the property between them. So that was the contention of the K. Mlinga. In his defense, Gharib said that K. had contributed nothing to the acquisition of the property of which she was claiming a share. Further, he contended that the premarital agreement, being a Danish contract, could not be enforced in Zanzibar. So that is another contention of the Gharib Abdullah. Apparently, High Court found the premarital agreement valid and enforceable in Zanzibar. The High Court found that the agreement covered all the properties owned by the parties before and after the marriage, be it in Denmark or Tanzania or anywhere. That is the decision given by the High Court of Zanzibar. In order that all the property mentioned by the K be evaluated and distributed between the parties. So that also made a further order. Gharib was accused by the judgment and appealed to the Court of Appeal of the Tanzania at Zanzibar, which quashed and set aside the judgment of the High Court. In the memorandum of the appeal, he listed 11 grounds with an alternative ground that The learned judge of the High Court had erred in law and fact in including as a matrimonial property liable for the distribution of the properties of which ownership had been established. So that was the contention of the Gharib Abdullah. According to the appellant, only the property which are acquired subsequent to the marriage were matrimonial property that could be distributed according to the contribution, and the marriage settlement was intended only for the properties in the Denmark and was wide regards properties in Zanzibar. So it is very much made clear that only the properties which have acquired subsequent to the marriage were matrimonial property that could be distributed according to the contribution, that the marriage settlement was intended only for a property in Denmark. So that is Denmark only be considered and was wide regarding the properties in Zanzibar. So it is the Zanzibar properties cannot be taken into consideration, and the contract of Zanzibar is, contract of the Denmark is valid, but it is not valid in Zanzibar. Issues. The main issue before the Court of Appeal were, what is that? Whether the Danish premarital agreement can be enforced in Zanzibar. I repeat, whether the Danish premarital agreement can be enforced in Zanzibar. Next, whether the premarital agreement covers all the properties owned by the parties before the and after the marriage in Denmark, Tanzania, or anywhere. So held that the Danish premarital agreement may be enforced in Zanzibar. Okay. The premarital agreement covered only the flat in Copenhagen, and the Court of Appeal quashed and said the order of the trial court, and all properties in the judgment be valued and estimated and distributed between the parties. However, the respondent can get the monetary value of her share for the immovable assets in Zanzibar of such value has been ascertained by a competent government valuer. So she will be entitled for the some of the portions which is there in Zanzibar. The appeal failed and came to get her cost. And how classifications applied in the Gharib Abdullah, I repeat, how the classification was applied in the Gharib Abdullah Juma Kemilinga case. What happened? What happened? Just a minute. What happened in that case is known as a conflict of laws in private international law. Classification is applied to solve the conflict. The following is how the Court of Zanzibar or the Court of Appeals of Tanzania applied the classification to handle the case. Yes, it's entirely different. First, the High Court applied the law of Zanzibar, the Lex Fori, to all procedural matters. For example, procedure and the admissibility of the evidence, and where court admitted them premarital agreement which was formed in Denmark by using the forum Zanzibar law. Second, the Court of Appeal applied the law of Denmark to determine the validity of the contract. It stated that once it is accepted, and the validity of a contract depends upon the law of the place where the contract was entered into, the Lex Lucy contractus. Okay. And third, in relation to the rule of law applicable in the ownership of the immovable property, High Court applied the rule of domicile, Lex domicile, to determine the legal status and the capacity of the rei to own immovable property situated in Zanzibar. Court of Appeal cement on that issue by stated all the question that arise concerning the right over the immovable, that is, were governed by the law of the place where the immovable property is situated, that is the lex situs. In conclusion, generally, the above discussion revealed that the concept of the classification under the private international law means the selection or classification of the cause of action under the rule of law applicable in dispute involving the foreign element. I repeat, generally, the above discussion revealed that the concept of classification under the private international law means the selection or the classification of causes of action and the rule of law applicable in dispute involving the foreign elements. It involves the classification of the cause of action and the classification of the rule of law. The main aim to apply the classification to solve the conflict of laws. So that is the today topic, and I think I have justified it. Perhaps if you have to present over there, naturally I would have to make the class as a participatory class, virtual class. But I don't know, the day has come there we can play, we can deal the class in a systematic manner. With this, I would like to stop our today's topics here, and bye.
Africa.